In the ideal world, you'd be able to pay off your loans and all the other debts you have. But sometimes situations present themselves that make that impossible. If you find yourself in a financial tight spot, you might be considering filing bankruptcy. Of course, this is a major decision that really shouldn't be taken lightly. It's important to understand what filing for bankruptcy entails and the effect it will have on your life and whether or not it's right for you. If you're thinking about filing bankruptcy, there is going to be a lot of numbers involved. Your income, your debts, the value of things that you own, otherwise known as your assets, among other things. Beyond that, there are three other very important numbers, 7, 11, and 13. They refer to the chapters of the bankruptcy code that your case may be filed under. It's absolutely critical that you understand the difference between these types of bankruptcy before you make any decisions. So to help you understand, here are some basics you really need to know. Chapter 7 Bankruptcy. Chapter 7 bankruptcy is often referred to as a straight bankruptcy. Under this type of bankruptcy, most debtors are able to discharge or eliminate their unsecured debts very, very quickly. Unsecured debts are those debts like personal loans or credit cards for which there is no collateral for the loan, such as a car, a house, an RV, or anything that has value. Chapter 11 Bankruptcy. This type of bankruptcy is most often used by businesses, but it can help certain individuals and small business owners as well. It allows consumers to restructure their debts and pay them back over time. Chapter 11 may be useful for someone who does not qualify for a Chapter 13. However, it is significantly more complex. Chapter 13 Bankruptcy. The goal of a Chapter 13 is also to eliminate debts. However, it creates a repayment plan where some or even all debt is repaid, usually between 3 to 5 years. Chapter 13 is often used in situations where someone wants to prevent their home from going into foreclosure or getting it out of foreclosure, perhaps restructure an auto loan to reduce interest rates or reduce the amount of the loan, prevent its repossession, or in situations where people can afford to repay some part of their debt but not necessarily all of it. So what are other key differences between Chapter 7, Chapter 11, and Chapter 13? And now that you know a little bit more about all three, how do you determine which one is your best option? Well, in most cases, Chapter 7 is faster. Most Chapter 7 cases take about 3 months to complete. On the other hand, Chapter 13 cases cannot exceed 5 years. Sometimes they're as short as 3 years, but typically they are 5 years. There is no specific requirement as to the length of a Chapter 11 plan, but is subject to a reasonableness standard as set by the court. Both Chapter 13 and Chapter 11 cases can allow you to keep certain assets that are possibly lost in a Chapter 7 case. But in reality, most bankrupt individuals in a Chapter 7 case usually do not lose any assets because typically what they have left after trying to stay afloat is protected by either state or federal law. But there are situations where you could lose certain assets in a Chapter 7 case that you would not lose in a Chapter 13 case. For example, if you have an RV or a boat with no loan against it, or if there's equity in it if you do have a loan, that is an item that you may have to surrender in a straight bankruptcy case. But in a Chapter 13 case, if you pay an amount of money into your plan equal to the amount of equity over a period of time, you very likely would be able to keep that asset. Both Chapter 11 and Chapter 13 cases may offer more help with car loans and mortgages. In a Chapter 7 case, if you're behind on these payments and you can't catch up, you may wind up losing that property. Under a Chapter 13, you may be able to catch up on these payments over a period of time using the Chapter 13 plan. Often you can use money that you're paying to credit cards or other personal debts that are unsecured by applying that money to the secured debt on a car loan or a mortgage in order to retain those assets. In addition, a very distinct advantage of a Chapter 13 case is that homeowners are able to wipe out a second mortgage on an underwater home or, in some cases, negotiate a modification of their primary mortgage by filing for this type of bankruptcy. Chapter 11 cases may be especially helpful to small business owners or real estate investors with multiple properties by allowing them to restructure debts or catch up on payments that are behind. Chapter 7 cases is generally much less expensive in legal costs than Chapters 13 or Chapter 11. With Chapter 7, you generally must pay your attorney up front, although most attorneys do set up payment plans. Also, most attorneys will instruct you to stop paying credit card or personal loan debts in order to help free up some cash flow in order to handle the legal costs that you have to pay before your case can be filed. In Chapters 13 or Chapter 11, you may be able to pay a part of your attorney's fees over a period of time as part of your repayment plan. Chapter 11 cases generally are the most expensive because of the higher filing fees that the court charges and because of the cost of the legal work involved due to their complexity. If all of this seems a little overwhelming at this point, relax. Good legal counsel is essential to the successful completion of a case. In many cases, a good attorney can advise you how to protect unprotected assets, time the filing of your case in order to qualify for the best chapter that fits your needs, and overall assist you with the successful completion for a fresh start. Also, it's important to remember that the cost of an attorney generally will fit into most persons' cash flow when you take into account that you can stop paying almost all of your creditors immediately with the help of your attorney representing you. For a free consultation, in order to answer any questions you have, we invite you to call us at 866-LAW-FIRM, which is 866-529-3476 from anywhere in California, or visit us at our website, www.equaljusticelawgroup.com. We have a very friendly, experienced, and helpful staff that will be glad to help you.